Hi there, this is Jonathan Ginsberg. I'd like to talk to you about the strategy I use to win a case when my client has significant impairment or damage to his or her knees. I've often felt that knee pain cases can be very, very good Social Security cases because judges realize that the knee being a primary weight-bearing joint is not something you can avoid. I mean, if you walk around at all, you're going to be using your knees, and when you've got really bad knees, and I'm talking about knees that are close to the need for knee replacement, then there's really no way to avoid a significant amount of pain, discomfort, swelling, and just overall miserableness, because bad knees can be very, very bad, very, very painful. So I happen to like knee cases. I know some attorneys don't. I happen to like them because I think that people with knee pain typically are very credible. It's pretty clear from the objective evidence from an X-ray or MRI that there's a real problem there. And I think judges find the combination of compelling testimony plus really solid medical evidence to be something that they can live with, and they can go ahead and approve those cases, and they frequently do. There are basically three ways to win a knee pain case. One is to meet what is called a listing, and the listings relevant to knee pain cases are listing 1.02 and 1.03. And basically, those listings talk about pain in a major weight-bearing joint or dysfunction of a weight-bearing joint. And the listings are where Social Security has identified specific medical conditions that on their face are so serious that you would not be able to work. So in other words, if you meet a listing, we don't have to really go into the work issues. It's presumed that if your medical diagnosis equals what Social Security is looking for, then you are automatically disabled. That's pretty much how the listings work. And I'd say the listings are typically where people are approved early. Maybe 10 or 15% of the cases meet the listing because, again, what the person, not the judge, but the adjudicator is looking for certain magic words in your medical record, and if those words are there, or if the medical record is so compelling, the adjudicator will say, yes, you do meet a listing, and you win. But it's not that common, even on cases that are really deserving. Probably the most common way to win a knee pain case is to argue functional capacity. What I mean by that is you argue that your capacity for work has been so reduced by your knee pain and swelling and discomfort and lack of function in the knees that you would not be a reliable worker. You would miss too many days of work because of pain and discomfort. You would have side effects. You would need to take too many unscheduled breaks. You would have difficulty with attention and concentration. You would have difficulty maintaining appropriate pace of work. You might have trouble interacting with coworkers and supervisors. You wouldn't be a good person to deal with the general public because you'd be in a bad mood because of the pain. You might be very forgetful because of pain. There's a lot of things that are associated with it, and that's what functional capacity is, that your capacity to perform has been very much eroded. I mean, walking is certainly going to be an element of that, and if you can show that your capacity to walk has been really, really reduced to the point where you really have no functional capacity to walk, there's no working capacity there, then basically that gets us down to sit-down type of jobs, and people with knee pain can't usually sit for more than 10 or 15 minutes. So that's why those cases typically work real well with a functional capacity argument. You would need to show ongoing treatment. You would need to show compliance with your medical regimen. You're taking the medications as prescribed. You're undergoing therapy. You would not be required to have surgery. If a knee replacement is necessary, you choose not to get it. The judges will not hold that against you. Because knee replacements are pretty invasive surgery, and it's something obviously that is very risky, and they don't demand that you take a risk with your life to try to get better in Social Security cases. So functional capacity is really the argument I use in most of my knee cases. You can also use a grid argument case, and what the grids are a third way to win. It is basically where Social Security looks at your age, your education, your past work experience, and the level of impairment that you've got physically. You have a physical level of impairment. It doesn't work for mental health cases, but for physical cases it does. And if your capacity for work has been reduced, even if you could do certain types of real entry-level sit-down type of work, you still could be found disabled under the grid rules if you're over 50. Because Social Security recognizes that people over 50, then there's another break point at 55, then another one at age 60, that people over age 50 are going to have a real difficult time finding entry-level work. And if you can't find a job, then there's really, obviously, you're not able to perform the work, and they realize that there's a real problem, especially in a tough economy for people over age 50 with a limited education, limited work skills, and so forth, that have significant physical problems. Those people would have a difficult time getting work. I've set out the grid rules on a site called gridrules.net, gridrules.net, where you can actually plug in your particular situation to the grid rules. Obviously, the judge is going to have to do that as well, but that kind of gives you an idea of how they work. And the grid rules can be a really fast and easy way to get approved, even if you can do certain types of work. So that's how I deal with knee pain cases. Have any questions? My contact information is on this site, and I hope this has been helpful, and we look forward to talking to you soon.